Hello there, welcome to LexisNexis Legal Talk podcast. It's great to have your company. My name is James Panichi. I'm a senior editor with MLex, which is a LexisNexis global media outlet offering independent journalism covering regulatory affairs. And I'm coming to you today from our offices in Melbourne. Now, Australia is on the cusp of the most significant revamp of its merger laws in decades, something that's largely been driven by concerns over digital platforms. It's all because, under the country's existing voluntary merger regime, Australia's antitrust regulator says it has often been overlooked by global dealmakers. According to the Australian Competition and Consumer Commission, significant global transactions, many involving digital companies, are either not notified in Australia at all, or the regulator finds out about them too late, and by then, of course, it's a done deal. So, the case for scrapping the voluntary regime is a compelling one, and here at MLex we've been covering every twist and turn of the proposed merger reform. But we also thought this might be a good chance to talk about mergers more broadly, to discuss how lawyers go about providing advice to Australian clients that are planning a transaction. And in the second part of today's podcast, we'll touch base with Jennifer Bannan, our strategic projects lead at LexisNexis Legal and Professional, and we'll go through the key steps that lawyers need to take with Jennifer's assistance. First up, though, we're joined by Ryan Cropp from our Parliament House offices in Canberra. Ryan is the journalist here at MLex who has been leading our coverage of the merger reforms and has broken several stories, making his articles a must-read for those working on mergers in Australia. Ryan, thank you so much for joining the podcast.
Thanks for having me.
Let's set the scene for listeners who might not be familiar with the regulatory landscape that we're dealing with here. What do they need to know?
What they need to know is that Australia currently has what's known as a voluntary or informal merger regime. And what this means is that companies are not typically under any particular obligation to formally notify the ACCC of deals that they want to do. And if they like, they can simply just go ahead and complete a merger. If the ACCC doesn't like that, it can then seek a declaration in the federal court to try to have it stopped. Now, that's a pretty risky strategy. So what companies typically do is informally notify the ACCC and seek its views on the deal. If the ACCC then thinks that deal raises concerns, it'll start its own informal review of the deal, and at the end of that review, it will come to a decision. Now, in this system, appeals of those decisions are heard in the Federal Court of Australia. So these are full merits reviews where parties can bring new evidence and do things like cross-examine witnesses. So that's the informal system. Now, Australia also has this alternative route for dealmakers that's known as merger authorisations. Now, this is much less commonly used, with only a handful really over the last 5 or 6 years. It's a much more formal review system, so it's got clearer timeframes and information requirements for companies looking to make deals. Appeals in this system are heard in the Australian Competition Tribunal, which is a specialist competition court. And the other important thing to note about merger authorisations is that it allows companies to get difficult deals across the line by making public benefits claims. Now, what this means is essentially that if a deal is likely to raise competition concerns, but it may have a public benefit, then companies can ask the ACCC to weigh that up against the anti-competitive detriments. And if the public benefits outweigh them, the deal can be passed. And we've actually seen a few significant decisions to this effect in the last 6 months.
Okay, so that's the state of play at the moment. Why does the ACCC believe that Australia needs to overhaul this regime? What's the problem that the ACCC has with how things stand at the moment?
The ACCC have quite a number of concerns, but they can broadly, I think, be fit into two baskets. So the first is the voluntary element. So the ACCC have pointed out that Australia is one of the only OECD jurisdictions where there is no mandatory requirement for companies to notify the regulator of mergers. And the ACCC thinks that it's not being notified of deals that may raise competition concerns as a result of this voluntary element. And this is both for small, incremental local deals, supermarkets and so forth, but also for big global deals. And on the global stuff, Australia, in the ACCC's view, can be a bit of an afterthought, as companies are under no obligation to formally notify them of the deals happening here. Now, the second major complaint is that the ACCC doesn't think it has the tools it needs to properly review key deals and then potentially stop them from going ahead. They don't think they're getting particularly good information out of the companies while they're doing their reviews, and they think that once they get to court, the odds are often stacked in favour of the merging parties, as the ACCC needs to convince a judge that a merger will substantially lessen competition in the future, which can often be very hard to do because the future is inherently hard to predict. And the ACCC thinks that it's consumers who wear the risk of this uncertainty.
Okay, so those are the concerns that the ACCC has. Now, ACCC Chair Gina Cascott-Lieb has a preferred model for reform. Walk us through what that model entails.
Yeah, so Gina Cascott-Lieb put forward the ACCC's preferred model in a speech in April last year, and the ACCC have really been actively campaigning on this model ever since. Basically, what they want to do is remove the voluntary notification component and replace it with a mandatory merger notification system. So companies will be required to notify if their merger met a set of predetermined thresholds. So there'd be no chances of companies sidestepping the ACCC with their mergers. Now, I'd say this is probably the least controversial element of the ACCC's proposals, and it's the one that would bring Australia into line, with most jurisdictions around the world. Where they've received more pushback, I think, is on the way those mergers should be assessed and how their decisions should be appealed. So the ACCC want to adjust the so-called onus of proof in deal reviews so that they must be satisfied that the deal won't lessen competition. And so this puts the onus onto the merging parties themselves rather than the ACCC. In most cases under the existing system, the ACCC is required to prove to a court on the balance of probabilities that a merger will substantially lessen competition. Now, the watchdog thinks this skews mergers towards clearance, and it wants to change that in the other direction. So that's one key issue. The other major issue is where the decisions are appealed. The ACCC wants their merger decisions to be appealed in the specialist Australian Competition Tribunal. This will be a limited merits review rather than a full-blown review, so parties couldn't bring new evidence or cross-examine. The tribunal would rather stand in the ACCC's shoes and judge whether that decision was right or wrong. And this all circles back to a really key fundamental issue for the ACCC, which is information gathering. The ACCC would rather parties provide information up front rather than strategically withhold it for later court battles. And they think that their system, their proposals, would incentivise companies to be more forthcoming with information. So the ACCC could then make better and more informed decisions on mergers.
Now, any change in Australia has to come about through government legislation. It's not something that the ACCC can simply do on its own. So how has the government responded to this call from the ACCC for an update to merger laws?
In the middle of last year, the government set up a competition task force within its Treasury Department. This task force was set up to review competition policy and specifically mergers. They peopled this task force with bureaucrats from all over government. So the ACCC had people there, the Reserve Bank of Australia, the Productivity Commission, the Finance Department, and they also gave this task force an advisory board that was itself peopled with a number of competition heavyweights. For example, former ACCC Chair Rod Sims, the current Chair of the Productivity Commission, Danielle Wood. So a few months later, the task force came up with 3 different models for Australia's new merger regime. Option 1 looked relatively similar to the existing system. It's pretty close to what currently exists in New Zealand. There was also option 3, which was basically the ACCC's model, as we just discussed. And then there was option 2, which is a more US-style model that would basically introduce mandatory notification but maintain the federal court for any appeals. So they're now reviewing these 3 different options and we're waiting to see which one they'll go with. The task force has also set up a data crunching division, and Competition Minister Andrew Lee recently released some preliminary results that seem to suggest that the ACCC was being bypassed quite a bit on mergers. The ACCC, according to this research, is only seeing less than a third of all mergers that are taking place in Australia each year. And the other key nugget of data he released was that the top 1% of companies accounted for more than half of all mergers occurring in Australia each year.
Okay, so that all points to the fact that the government is taking the ACCC's claims seriously, if nothing else, although we don't know which of those 3 models that you've just listed the government will ultimately choose, or whether it'll in fact pick and choose bits and pieces from all of those models. But what's next, Ryan? I mean, what's on the horizon at the moment?
Well, the government's pretty widely expected to make an announcement about its preferred model in the not too distant future. I mean, one of the members of the task force told a parliamentary committee a few weeks ago that they are expecting to make an advice to the government in the near term. So this could be as soon as the next few weeks. It's really anyone's guess. There's a lot of rumours swirling around, for example, that the decision's actually already been made or it was made in early February. But what we can say, I think, is that there's a pretty widespread assumption that mandatory notification is coming, just based on the noises that the government has been making and the fact that there probably hasn't been as much pushback on that aspect of the proposals. On the other parts of the ACCC's proposals, I think there's much less certainty and, chances are it won't be long till we find out which way the government wants to go.
Ryan, thank you so much for chatting today. Thanks for all of your coverage over recent months. It's been great.
Thanks, James.
Ryan Cropp is MLex's Canberra correspondent, and he was speaking to us from the LexisNexis offices in Parliament House. And MLex subscribers will see that we've created a portfolio of all reporting on the merger reforms. It's very easy to find, and there's also a handy timeline that will help you make sense of it all. But now let's talk about the practicalities of mergers from the perspective of the lawyers working on different cases. Jennifer Bannan is LN Pacific's Strategic Projects Lead for Strategic and Global Partnerships and is also a lawyer with many years of competition law experience, both with Australian law firms and as in-house regulatory legal advisor for multinational companies. And Jennifer is with us right now from Sydney. So, Jen, let's start from the very beginning here. Can you tell us something about what's involved?
Sure. Well, and I think mergers are such an important part of our economy, so I love this conversation, and they have great potential to drive growth and innovation, from synergies that result from alliances and in helping to ensure that consumers benefit from these transactions. But of course, it doesn't always play out that way, which is why competition laws exist to ensure, or at least seek to ensure, that mergers that do go ahead are not likely to substantially lessen competition. But in terms of how a competition lawyer will get involved in a prospective merger, generally that's through receiving a call from the corporate department who might have a client that's involved in a merger or acquisition, or the client might come directly to the competition lawyer for advice on whether they think a merger can proceed. And the client could be the company that wants to acquire a target. It could be the target, or it could even be a third party wanting to know if they can comment on a merger that's happening amongst players in their space. And so the task or the question to be answered by competition lawyers is that merger parties want to know whether the transaction is likely to be approved by the ACCC in Australia. And if it's a global merger, they'll want to know if they need to notify in other jurisdictions, and they may want advice on whether it's likely that the competition law regulator will approve that transaction. So you've already covered that Australia is one of the only OECD jurisdictions that doesn't have a compulsory notification system. So the issue becomes working out if you should notify the ACCC and through what means, whether that's through the informal notification system or through a formal authorisation. And then separately, if they think that there are likely to be competition issues and whether they might need to even propose some Section 87B undertakings or conditions that might need to attach to the transaction in order to gain the approval of the competition law regulators.
Okay, so there are a lot of questions there that have been put to the competition lawyers. How do they approach the task of giving prospects advice on a new merger proposal? How do they go about their work?
The first step is really one of research. They need to research the parties involved and identify the areas of competitive overlap between those two parties. And that's so that you can work out what is the relevant market for analysis for this transaction, because Section 50 of the Competition and Consumer Act prohibits companies from entering into a merger or acquisition that has that effect or likely effect of substantially lessening competition in a relevant market. So that key term is relevant market, and that's that first step. What is the relevant market for the transaction? So a good example might be if it's a large alcohol manufacturer taking over a small Australian winery, you would need to start by working out the scope of the market from a product point of view. Is it alcohol? Is it wine? Is it red wine? Is it even narrower? Is there a market for the type of grape? Is there a market for Shiraz? And then you've got to consider other types of aspects of the market, like the functional level of the market, if they're producers or distributors, and then there's the geographic scope of market definition. So, is there a relevant market in McLaren Vale, or is it more broad? Is it something like southeastern Australia or Australia, and so on? So that first step is really very research intensive, and it's all about working out what are the boundaries for analysis, because so many things flow from that. So, the market shares of companies in the relevant market will flow from however you've defined that market. And if you've defined the market too narrowly, then you're going to overstate the merger parties' market shares. And if you make it too broad, then you'll be understating their market shares. So it's critical to get that first piece right. Of course, market definition also affects things like the level of concentration and what are the barriers to entry and how many players are in that market and what's the state of competition in those markets. So this research exercise is extremely time consuming.
But Jen, who within the law firm undertakes this research task, and how do they currently go about it?
The way it's done in law firms generally is that a junior lawyer or a paralegal or a summer clerk will be tasked with taking that first step of researching market definition, and they'll go to the ACCC's website and they'll look at the merger register, and they might enter the party names to see what transaction the merger parties have been involved in the past. And they might also look for their competitors, and they might also just research generally the industry. So they might type in alcohol or wine or so on to see what prompts they'll come up with. But it's very time consuming. It's a very sort of clunky exercise. It's an art. There's not a science to it. And it's really a matter of piecing things together. It's a bit of a jigsaw. And of course, if you've got a global or international transaction, you've also got to go that next step further, which is to look at, what has happened outside of our own jurisdiction and have international regulators considered these types of markets. So,
and does this international side of things involve contacts with law firms in other jurisdictions?
It could do, yes. You might have law firms across the globe involved in the transaction. But if you don't, then you might want to just do that own research yourself and look to the competition law authorities in those international jurisdictions and search their websites to see if they've considered those transactions. But I think it's safe to say that if you do have a law firm that's on the transaction with you, that they would take control of the research and analysis generally for their own jurisdiction, and they'd cover that for you.
And look, without wanting to do too much promotion for a LN product, I know that the company has in fact been working on a solution to what is, as you've explained now, a very time-consuming research problem. Can you just in a few words tell me something about that?
LexisNexis now has a solution to this exact issue that we're talking about, this very time-consuming research exercise, and it's through a product called CaseLex. It's a market intelligence database. It has over 23,000 merger control decisions across the globe, and it covers 70,000 market definitions. So you can research this database of decisions that have been released by competition law authorities globally and cut down that sort of manually intensive research time. And in the past year or so, it's been enjoyed by our customers across Europe. So there's over 100 law firms, and also many of the competition law regulators themselves use CaseLex now to help them identify relevant markets in merger transactions. And really just help you get to that step of the competition law analysis, if you like, much quicker. And that's a great result because, of course, mergers are often very time pressured and time is of the essence.
Jen, thank you so much for talking to me today. Really appreciate it.
Thanks very much, James. I enjoyed it.
Jennifer Bannan is Strategic Projects Lead at LexisNexis, and she joined us from Sydney. And that's it for the LexisNexis Legal Talk podcast. Today's edition was produced and presented by me, James Panichi, Senior Editor at MLex in Australia. And from everyone here at LexisNexis, thank you very much for listening. I hope you can tune in again very soon. Bye for now.